the list, that is first a fee. That is in the admitted matter. In the meantime, of the execution procedure has been started, and the notice was issued by to the respondent. One of the respondents were received the notice, but his representative was received. Thereafter, but again, notice was received and has been received and they have appeared. But in the meantime, the execution proceeding had started. So we are taking
नोट सेकंड में भी इसलिए नोटिस 4 के लिए लिस्ट में है, लेकिन आउट ऑफ लिस्ट में
तो आउट ऑफ लिस्ट है 29/4 को ऑलरेडी डेट फिक्स्ड है।
आइए देख लिए आई आल्सो फॉर आइए फॉर अर्ली
प्रीपोनिंग द डेट ऑफ हियरिंग
और इट मे बी मोर ऑफ द आइए इट मे बी फॉर स्टेइंग ऑफ दिस एक्सक्यूशन प्रोसेस।
अदर साइड अपीयर होने के बाद हम स्टे पे नहीं सुनते।
अदर साइड में क्लियर हो चुकी
तो स्टे पे आप थोड़ी सुनेंगे। अदर साइड अपीयर हो गया तब क्या स्टे? फाइनल डिस्पोजल।
हम फाइनल करें
क्या मैटर?
ये मैनी शूट है
आप प्लेंटिफ इंडिपेंडेंट
हम प्लेट वहाँ डिफेंडेड
आइए कौन सा है आपका? पहले फाइल किए थे कि बाद में फाइल किए?
भी इधर हाल की एक्सक्यूशन की स्टार्ट होने के बाद
एग्जीक्यूशन में क्या हुआ? नोटिस हुआ होगा।
नोटिस में जो उसमें
मनी सूट में क्या रिकवरी करेगा? क्या कैसे?
हमारी सर्टिफिकेट देने के बाद मुझे नोट है गिविंग डेट एंड द प्रोसीजर
डेट तो दे रहे होंगे लेकिन कैसे रिकवरी करेंगे? व्हाट इज द मोड ऑफ रिकवरी? मनी सूट में क्या रिकवरी करेंगे? रिकवरी ऑफ पोजीशन की तो बात है नहीं, isn't it? कोई अर्जेंसी नहीं।
सूले उसमें तो सूले आता तो कैन डेट उसको प्रीपोनिंग करके या उसको फिर स्टे कर
कोई स्टे का कोई रिक्वायरमेंट नहीं है, डेट ऑलरेडी फिक्स्ड है। वैसा अर्जेंसी होता तो हम जरूर
तो
करते।
उसमें 3 डेट से चल रहा था 3 डेट के बाद
लेकिन इतना कैपेसिटी हमको नहीं है।
नहीं आपको उम्मीद नहीं कर रहे हैं कर रहे
कुछ नहीं हो रहा आपके एग्जीक्यूशन में। मनी सूट का रिकवरी जो है दूसरी तरह से होगा। रिकवरी ऑफ पोजीशन नहीं है ना कि आपको डिस्पोजेस कर देगा किसी चीज से। ओके नेक्स्ट।
From the supplementary list, underwriting was final disposal. Fresh filing, item 1 DA 1876.
These registered under NDPS Act. Persons were apprehended by the police on suspicion from a car. And from their possession, ground sugar was recovered, which is intermediary quantity. And the confession, the police has raided the house of such a petitioner.
आपके घर से रिकवरी है ना?
Yes, madam. I recovered from my house. Other persons whose recovery was made have been granted bail and a petition. The persons who were first apprehended have been granted bail and from the court. And the second thing is that that is not recovered from the conscious possession. There is no antecedent against the petitioner. Other persons are in position house and my wife has also been arrested. They all have been.
आपका नाम है?
मेरा नाम है सैयद समीर. First person is Amit Kumar Gupta and Nitish
That's
and they are confession mine.
you are the supplier. They are the consumers.
Neither I am supplier and it has said that these persons were also seeking for selling of the same and they are selling, not supplier, they are selling. It has been alleged that the petitioner and other political persons are selling the same, but it was not recovered from the market. Rather, they were the co-accused persons were apprehended while they were selling it, and it was recovered from my house. Neither I was selling it nor it has been recovered from my
ये
house.
number 1876 of 2026.
Note one, the co-accused bail was rejected not by this coordination yesterday.
But here we know from the
On
That's BA number 107 of 2026. Yesterday it was
due to
107 of
2026.
Yesterday.
Yesterday, but he was also present, but due to as she had one antecedent, therefore it was. But I have no antecedent that.
Heard the learned counsel separating on behalf of the parties. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case, and there is recovery of 105 gram of brown sugar and 1.0 alleged recovery, and 1.06 kilogram of ganja, and cash amount of ₹1,18,630 from the house of the petitioner, but such recovery is not from his conscious possession. His wife has also been made an accused in this case. He has submitted that the co-accused persons who were selling the brown sugar have been granted bail by this court, in namely to Amit Kumar Gupta in DA number 1664 of 2026 and DA number 835 of 2026. 835 में Mukesh Kumar. The learned counsel for the state has opposed the prayer and has submitted that the wife of the petitioner has also been refused bail by this court in DA number 107 of 2026 by a coordinate bench of this court yesterday. And the petitioner is the supplier of narcotics. With this, the learned counsel for the petitioner has submitted that the bail application of the wife has been rejected on the ground that she had a criminal antecedent. After hearing the learned counsel for the parties and considering the fact that huge quantity of narcotics has been recovered from the house of the petitioner, and the co-accused, that is his wife, has also been declined bail by a coordinate bench of this court in DA number 107 of 2026, and they are alleged to be the supplier of narcotics. This court is not inclined to enlarge the petitioner on bail. So far as the co-accused who have been granted bail by this court is concerned, it was only 14 gram of brown sugar was recovered from Mukesh Kumar, and 35 gram of brown sugar was recovered from Amit Kumar Gupta, who claimed himself to be a drug addict and claimed that brown sugar was kept for his own consumption. The case of the petitioner is on different footing. This court is that's all.
From the daily list, under heading for press filing, item 2, DA.20.09.3 of 2026.
Petitioner absent. State is also absent.
Item 3, DA.20.98 of 2026.
Your father?
Brother of the informant named Islam Auto went to missing. Suspicion had been raised against the petitioner. The petitioner had modified some relationship and
There is recovery also from you. Yes.
Yes, कोई has been
Slipper of the deceased has been recovered and the eco van used in the crime has also been seized.
Yes, ma'am. हमारे घर से वो तो हमारे भतीजा है
आपके कन्फेशन स्टेटमेंट में रिकवरी है,
तो हमारे घर में वो रेगुलर विजिट
आपके घर से रिकवरी।
हमारे घर में हम तो कहाँ करेंगे नहीं हमारे घर में नहीं आएगा डेड बॉडी हमारे घर में नहीं है कोई आई विटनेस हमारे नहीं है मारने वाला हमारे घर में हमारे भतीजा है हमारे घर में तो आएंगे नहीं।
There was an earlier dispute for which I
आपको सेटल हो चुका है
while my brother was missing, I have lodged a SANA also. That I have a suspicion against the petitioner and on his confession, Your Worship, the slippers of the deceased and the van which was used in the crime has been recovered.
कोई वेपन जिससे क्या मर्डर किया हो ऐसा कुछ रिकवर चाहे उस पे ये हो तब हमारा भतीजा हमारे घर में
Page
आए
21, last 4 lines are included.
डायरी नहीं है
Well, what my learned friend is saying, the place of recovery is from Lutpet प्राथमिक विद्यालय के सामने रोड के किनारे झाड़ी के दक्षिण साइड में the slippers have been recovered, not from his house.
Page 21 in the interim order, it was clearly stated. On the confession statement of the slipper of the deceased, the recommended bearer 30 and 31. Though diary has not been received, the interim order it has been clearly stated.
और मैं नहीं को मैं कन्फ्यूजन में कोई
Heard the learned counsels of hearing on behalf of the parties. The counsel for the informant is also present. The counsel for the petitioner has submitted that though the petitioner is named in the FIR, but there is only suspicion against the petitioner. And there is allegation that the petitioner had illicit relationship with his auntie. है ना?
but matter is settled
That's, he has submitted that. The matter has been settled outside. Counsel for the informant has opposed the prayer and has denied the plea of settlement and has further submitted that the Asanha was also earlier lost against the petitioner and
again the petitioner again the missing
No, against the petitioner.
like kindly see your page
मेरे
number
द्वारा दिनांक 27 को मेरे छोटे भाई कृष्णा मार्को को इसके संबंध में आवेदन दिया गया था तथा साथ ही इस संबंध में विरोध थाना में दिनांक 27 को शक जताया गया था दर्ज की गई थी
दो
इसमें
चीज को एक साथ किया गया
so unka submission. He has also submitted that on the confession statement of the petitioner, the slipper of the deceased and the eco van used in crime have been seized. After hearing the learned counsel for the parties and considering the fact that the petitioner is named in the FIR, though on suspicion, and on his confession, there is recovery of the belonging of the deceased, and also the eco van used, allegedly used in the crime. This court is not inclined to enlarge the petitioner on this subject.
No, only the petitioner को just location होगा actually. Location होगा because his great application will also be.
Why have you?
कोई कुछ नहीं granted
Item 4 DA 2109 of 2026.
Yes, please.
The matter relates to section 62 and 62 of the BLS and POCSO Act. The allegation of this petitioner and the other co-accused.
Allegation is very serious and there is direct allegation.
There is a delay of 2 days in fact.
That is material.
And he is in custody since 1 year. There is no medical report also required. He is taking the report.
Not required.
There is a family dispute with the lordship.
Custody since
6/3/2025. Almost a year.
heard the learned counsel appearing on behalf of the petitioner. Nobody appears on behalf of the opposite party. The learned counsel for the petitioner has submitted that the petitioner has been falsely implicated in this case and there is land dispute between the parties. She has submitted that there is the FIR has been lodged on 24/1/2025 or has been lodged on 26/1/2025 with respect to the LA's incident dated 24/1/2025. Yes, she has also submitted that there is no medical examination and the charge sheet has been submitted on 6/3 on charge sheet and charges have also been framed. The petitioner is in custody since 6/3/2025. The learned counsel for the state has opposed the bail for bail. After hearing the learned counsel for the parties, this court finds that the victim has filed the case and there is direct allegation against the petitioner. It has also been alleged in the FIR that somehow the victim and his sister, the informant and his sister, aged 12 years, could somehow escape from the clutches of the named accused. And it has also been mentioned in the FIR that the victims were under a fear from the petitioner. Considering the direct allegation made against the petitioner, this court is not inclined to enlarge the petitioner on bail, open or included. The interim order also reveals that the statement of the victim has been recorded under section 183 BNSS and the victim has fully supported the case of the prosecution.
Item 5 DA 2120/2026.
The content of the FIR at page number 16. The several questions have been granted by your Honor. Even the Minhaj Ansari and Moiz Ansari were infected with specific injury to the informant, they have also been granted bail by the Senate Court below. 3 of the accused person has been granted bail by the coordinate bench yesterday, Your Lordship. And the conclusion that
Who all have been granted bail?
Yes, the Abu Rehan Ansari has been granted bail. Naseem Ansari has been granted bail. Museed Ansari has been granted bail.
Museed Ansari.
Ijaz Ansari has been granted
मुशीद का नाम नहीं लिखा।
Mujia Ansari के just बाद है second line
मुजिल्ला अंसारी मुर्शिद अंसारी
yes
और
Ijaz Ansari has been granted bail.
इजाज जस्ट
मलिक
इजाज का नाम कितना
पिटीशनर के बाद में मलिक
टीचर
अंसारी
का क्या नाम
मलिक अंसारी मुर्शिद अंसारी के just बाद है पिटीशनर का नाम
अच्छा मलिक अंसारी he has been granted bail
no
he is the petitioner
yes
और इजाज अंसारी has been granted
yes Ijaz Ansari has been granted bail. Walid Ansari has been granted bail.
Walid
Ansari has been granted bail. And Bablu has also been granted.
ये सारा डिटेल आप लिख के दे देंगे
I have the copy of the order.
The specific allegation is of assault is on Minhas Ansari.
And Moiz Ansari. They have also been granted
By whom?
by the learned court below.
Where is the order? आपका कस्टडी कब से है?
My custody is your 3/2026. These are the orders of the and the coordinate bench has been granted that has not been uploaded till today at 30 or the address is there. Finding the court below is the land is good.
And the custody was since 9/12/24.
These two persons who have inflicted injury to the informed, they here.
The ground of custody.
Yeah.
How much is your custody?
My case, my custody is 3/2026.
Charge sheet has not been filed.
There are three of the accused persons yesterday has been granted bail. That
Charge sheet has not been filed against you so far.
Sorry,
Charge sheet has not been filed.
Dr. Musid Ansari, Wajid Ansari, and Ejaz Ansari having same custody. Yesterday they have been granted bail by this honorable court coordinate bench.
क्या बोले?
Direct allegation है, naming है।
डायरेक्ट एलिगेशन तो मिन्हाज अंसारी और मोइज अंसारी
पर ये
थे तो साथ में, वो तो ठीक है, थे इसीलिए ना केस है, नहीं तो क्यों ही खड़े हैं यहाँ?
Have been granted. Musid Ansari, case of Musid.
Heard the learned counsel appearing, counsels appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case, though he has been named in the FIR. He has also submitted that there is specific allegation of assault against Minhaz Ansari and Moiz Ansari, and they have been granted bail by the learned court below by the order dated 6/1/2025. However, it transpired that the bail was granted on the ground that they were in custody since 9/12/2024 and there existed land dispute between the parties. To this, the counsel for the petitioner has submitted that the other co-accused who are similarly situated have been granted bail by coordinate benches yesterday.
Yeah.
The details are as are there.
Yes.
नहीं तो ऑर्डर ही अपलोड नहीं होगा.
Okay.
And the petitioner is in custody since 3/2/2026. The learned counsel for the state has opposed the prayer for bail. After hearing the learned counsel for the parties and considering the fact that number of co-accused persons have been enlarged on bail, as mentioned by the counsel for the petitioner, the petition is also directed to the national bail.
Item 6, DA.21.27 of 2026.
This is similar fish. Allegation under section 318, 318, 74, 349, 338, 336 of 3, and 355 of BNS, and 103 and 104 of Trademark Act, and section 5 of Environment Act. इसमें allegation investigations surprise in possession of this 53 days का कस्टडी है इसमें, और इसमें एलिगेशन है कि मुझ पे मैं पिटिशनर हूँ और मैं एक मैकेनिक हूँ.
कब से आप कस्टडी में हैं?
कस्टडी सरप्राइज से पोजेशन में 53 डेज. अरे मैकेनिक मेरा वर्क है, मैं मोबाइल रिपेयर करता हूँ और ये रंजीत जिनका मेन मार्केट बाकी में मोबाइल की दुकान है, उनके इंस्ट्रक्शन पे ही मैं मोबाइल बनाता हूँ। और ये पुलिस जो है ये सेल्फ स्टेटमेंट भी केस रिकॉर्ड करेंगे।
FIR किसने किया?
ये SI पुलिस स्टेशन के इंचार्ज है राजेश रंजन जी, उनके सेल्फ स्टेटमेंट रिकॉर्ड है।
क्या बोलना है आपको? ट्रेडमार्क का वायलेशन है। Apprehended with huge mobiles
That's fact.
और रिपेयर फैक्ट्री कर
Yes.
जिले भी दे देंगे आपको। ट्रेडमार्क का कोई तो आया ही नहीं, कोई पार्टी आया आपको ट्रेडमार्क का वायलेशन बोलने के लिए? कोई तो आया नहीं, कोई प्राइवेट पार्टी तो आया नहीं कि ट्रेडमार्क का वायलेशन हो। और सिम और मोबाइल वहाँ बैठ के खुद बना लेंगे फैक्ट्री में, बन जाएगा। आपका फोन बन जाएगा वहाँ पर।
लीगल मटेरियल था बनाने का, मोबाइल जो रिपेयर करता था, दैट हैज कम इन द
कोई एंटीसीडेंट भी नहीं है।
एक्यूज नंबर 2 का यस्टरडे बेल हो गया है। रंजीत ऑर्डर अप्रूव नहीं है,
कल बेल हुआ।
सेम डिवीजन से
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petitioner submits that the petitioner has been falsely implicated in this case. Although the petitioner is engaged in repair of mobiles, we have submitted that there is allegation of violation of Trademark Act and also Environment Protection Act. The learned counsel submits that the petitioner is in custody since 27/1/2026 and the co-accused, namely Randeep Kumar, has been enlarged bail by coordinate bench of this court on 16th of March 2026. And the petitioner is in custody since 27/1/2026. The learned counsel for the state has opposed the prayer. After hearing the learned counsel for the parties and considering the nature of allegation and that the petitioner claims to be a mechanic of mobiles and the co-accused having been enlarged on bail, the petitioner is directed to be enlarged on bail. Petitioner has no criminal antecedent. ये criminal antecedent वाली ठीक लिखे ना बात आप, आपके petition में है no criminal antecedent.
Item 7 BA 2128 of 2026.
None of the sections are applicable in the case. The petition is in this matter on the basis of confidential information. It came to know that some persons are used to sell and purchase the arms. Getting this confidential information, it was constituted as illegal and proceeded for the ship. And when they reached, then they found that 2 or 3 persons see the police party started to follow. One person succeeded to fail. This petitioner was apprehended and from his position, mobile that is no dispute and 2 cartridges were. And subsequently, it is alleged that
Antecedent.
no accident, for 20 arrested. And who is also granted, who is being.
Para 20.
But, 21 is it.
क्या बोलना है?
Yes, madam. इसके पास से 2 cartridges recover हुआ है.
कस्टडी कब से?
There are two cases. More than 8 months.
Heard the learned counsel appearing on behalf of the parties. The learned counsel for the petition submits that it has been alleged that the petitioner is involved in commission of organized crime and only 2 cartridges have been recovered from the possession of the petitioner. The learned counsel has submitted that the petitioner is in custody since 13/16/2025 and has no criminal antecedent as stated in paragraph 20 of the bail application. He has also submitted that the co-accused, namely
Sir, की अपने तारीफ करके सिंपल में ये बाद में उनका नियम है
तो co-accused, namely Saklen, इसका नाम लीजिए, has been enlarged by on bail by coordinate bench of this court in BA number 1690 of 2026. आरिफ रजा कौन?
आरिफ को बाहर जाता है कंफेशन दूसरे ही लोग हैं कंफेशन he disclosed that he was his name was Haris. The confession of what he knows.
After hearing the counsels, the counsel for the state has opposed the prayer for them. After hearing the learned counsel for the parties and considering the submissions, and also that the petitioner has no criminal antecedent as stated in the bail application, and co-accused has been enlarged on bail by coordinate bench. The petitioner is directed to be enlarged on bail. The learned court, before releasing the petitioner on bail, the learned court shall call for a report with respect to the criminal antecedent of the petitioner, and if any antecedent is found, the petitioner will not be enlarged. Okay.
Reading for admission item 8 DA-12056 of 2025.
Initially, your worship, the case was filed under section 406, 420 and 307 of IPC worship. Subsequently, after submission of charge sheet, 307 was removed. Now the case is that from the FIR itself, your worship will find it's a dispute between land brokers, your worship, and it's a contract was violation of the terms and conditions. From the
Since
FIR
when are you
itself.
in custody?
Sorry?
Since when are you in
Yes.
custody?
I'm in custody since 10/11/25, since 4 months. Two agreements were there, your worship, between the parties, in which, your worship, some commission was to be given to the informant. In both the agreements. In first agreement, both the agreements were of 29/2020.
What do you say, ma'am?
Yes, I find counter also this. Plus one of the witnesses is as stated his 169 statement is at para 3. Because he had accompanied the informant to the place of petitioner Mills where they were demanding money and the petitioner refused to give back the money. The argument is there.
The entire case is arising out of term violation of terms and conditions of the agreement. Primarily a civil dispute.
Okay, so
For the learned counsel appearing on behalf of the parties, the counsel for the petition submits that as per the allegation, the case arises out of violation of terms and conditions of the agreement. And essentially the case is semi-dispute. The petitioner is in custody since 10/11/2025. The learned counsel for the state has opposed affair by submitting that the witness has supported the prosecution case. And it is alleged that the petitioner had entered into an agreement with the informant in the year 2020 and taken rupees 5,000 from the informant, but neither gave land nor returned his money back.
5 lakhs.
5 lakhs is there. 2
5
agreements
lakhs.
were there. One for 5 lakhs, one for 2 lakhs. And some commission was to be given to him if the lands were sold. So commission was also not paid. That is the allegation. Both the annexations were also not part of the agreement. Both the agreements.
After hearing the learned counsel for the parties, and considering the fact that there is dispute in connection with exchange of money arising out of an agreement of sale, and the petitioner is in custody since 10/11/2025, the petitioner is directed to be enlarged on bail.
Item 9, DA852 of 2026.
Aim to withdraw this petition.
Also for the petitioner seeks permission to withdraw this bail application. This petition is dismissed.
साइन कर लीजिए. Item 10, DA906 of 2026.
Lordship, I had to file a supplementary affidavit with Lordship.
Or what?
It is almost complete.
Or
We
what?
have report one certificate, Your Lordship, in which the petitioner has voluntarily surrendered under the Jharkhand government scheme for rehabilitation of the extremist.
So,
This wrong has been granted with some other cases.
I will not grant you this.
I'll argue on the next one.
You are your minutes. इसके लिए बेल नहीं हो सकता. आपने surrender कर दिया. You admit everything. That you are a part of this team.
But there is no specific allegation, and several other co-accused have similarly situated. Several other co-accused have been granted bail. 8 accused persons.
कितना antecedent है? 4, 8,
Antecedent.
8 antecedents.
Several units he has been acquitted, and in other cases he has been granted bail by the.
बस एक ही केस बच रहा है क्या बेल से?
नहीं, एक और इसमें he is in open jail units and he is undergoing rehabilitation.
You better undergo rehabilitation. बाहर निकल के और यही सब लोगों के लिए फंस जाएगा. It's for your benefit. मेरिट पे देख. और the learned counsel is pleading on behalf of.
Charge has been framed, Your Lordship, and he is in custody for 9/25.
1/25. Input of the bill.
Heard the learned counsel is pleading on behalf of the parties. A supplementary affidavit has been filed by the petitioner during the court proceedings, which is taken on record. The learned counsel for the petitioner has submitted that the petitioner has voluntarily surrendered on 24/4/2025 under the Jharkhand government scheme of extradition and rehabilitation of left wing, and thereby the petitioner has demonstrated his bona fide intention to return to the mainstream and cooperate with the administration. The counsel for the petitioner has submitted that the petitioner has been kept in open jail and is being rehabilitated
And he
by
has
the
been,
government.
and he has been given several benefits like house and
And he has also been provided with several
benefits
as per the scheme.
and his children are being
The Learned Counsel for the state petitioner has also submitted that several co-accused have been enlarged on bail, including Babulal Ganju in VA number 426 of 25, Raju Yadav in VA number 4099 of 2024, Baleshwar Ganju in VA number 3150 of 2024, Vikas Kumar Thakur in VA number 1913 of 2021, Lakshman Ganju in VA number 15298 of 2021, Sikandar Ganju in VA number 2445 of 2022, राकेश गंजू का 2 ऑर्डर लगा दिए हैं Rakesh Ganju in VA number 4674 of 2025 and Ramesh Ganju in VA number 8774 of 2022. ये सब सेम केस से राइज करना है?
yes sir.
The Learned Counsel for the state has opposed the bail
And they were also under
and has submitted that the petitioner has as many as 8 criminal antecedents and merely because he has surrendered as per the scheme, the same may not be a ground to release the petitioner on bail. He has also submitted that the petitioner belongs to the band. The petitioner is active member of band TSPS extremist organization, and from the place of occurrence, huge quantity of arms and ammunition and other natural articles were recovered. After hearing the Learned Counsel for the parties and considering the numerous criminal antecedents of the petitioner,
there is no specific allegation against him in this case. इसी में
the
नहीं है
court is
बस
not inclined to enlarge the petitioner on bail.
at this stage.
As submitted by the petitioner is already undergoing rehabilitation under the scheme.
At this stage.
But please at this stage ही हो सकता है। आपके इंटरेस्ट में है कि आप इन लोगों से दूर रहिए।
सब लोग जिनका बिल पास सब लोग रिहैबिलिटेशन
Item 11 BA 907 of 2026.
Also for the petitioner does not want to press this bail application. Accordingly, this petition is dismissed as not pressed.
Sign for. Item 12 BA 916 of 2026.
रेडी है
आप कॉपी मिली?
I received yesterday. It will be also taken next week also. Just yesterday I have received.
टाइप करना पड़ने में कितना टाइम लगता है? इसका रिजॉइंडर का तो कोई स्कोप नहीं है।
रिजॉइंडर नहीं मैं यूनिवर्सिटी लेकिन उन्होंने एलिगेशन लगाया उससे
क्या
उसको
allegation?
वेरीफाई करना
क्या एलिगेशन लगाया बताइए? क्या चीज़ आपको वेरीफाई करनी है?
I have to see the case diary and all because
आपके पास केस डायरी है?
नहीं हमारे पास
फिर कैसे देखिएगा?
हम क्लाइंट से कल बात की
टाइम तो मिलता है?
यूनिवर्सिटी को चार्जशीट has been submitted and papers have been supplied.
BA number 916 of 2026. The counter affidavit has been filed during the court proceedings, which is taken on record. ये आपके पास केस डायरी आ गया?
हाँ
The counsel for the state has submitted that he has also received the case diary. देख लीजिए। दिखा दीजिए अभी इनको, है ना?
Any date you want?
Date नहीं, post tomorrow. The case ID be submitted to this court by 4 o'clock. 4 बजे तक यहाँ पे दे दीजिए. फोटो कॉपी करने में कुछ करना, फोटो कॉपी नहीं करना है, यहीं पे बैठ के आपको जितना दे देखना है देखिए. कोर्ट के अंदर ही बैठ के देखिए आपको जितना दे देखना.
आइटम
अभी
30
केस डायरी हमारे कस्टडी में आ चुका है, लेके बाहर मत जाइए. जैसे इनका देखना हो जाए ना, वापस ले लीजिए.
Item 13 BA 1088 of 2026.
शायद केस है हमारे हम
बिहार ले जा रहे थे आप, और कोई जगह नहीं मिला ले जाने के लिए. इन ट्रांजिट टू बिहार. हाँ,
तो हम झारखंड में ही पकड़ा है, बिहार में नहीं लेके आए और कोई भी उसका बेल हुआ है सिंगल. और हम सिर्फ प्रोफेशनल ड्राइवर हैं, हम तो आए
एंटीसीडेंट भी है ना आपका.
हाँ वो इंसिडेंट
प्रोफेशनल ड्राइवर है, अपने गाड़ी को देते हैं, यही सब काम कर रहे हैं.
हुजूर कोयला चोरी का केस है, साइकिल से ले जा रहे थे.
कोयला चोरी का केस थोड़ी है ये.
ना जो दूसरा क्रिमिनल एंटीसीडेंट
अच्छा,
वो अपने घर पर ले जा रहे थे कोयला साइकिल से, उसी का केस है जो क्रिमिनल एंटीसीडेंट.
कोयला खान.
हाँ 2019 का है. और कोई ऐसा नहीं है कि हम प्रोफेशनली कहीं लीकर ट्रांसपोर्ट कर रहे थे या और कोई क्राइम कर रहे थे, इस तरह का केस.
कहाँ पकड़ा है? बॉर्डर पर.
जामताड़ा में पकड़ा गया.
जामताड़ा से बिहार का बॉर्डर मिलता है?
जामताड़ा से तो बंगाल का भी मिलता है.
बिहार का मिलता है कि
नहीं मिलता है. उसके बाद दूसरा डिस्ट्रिक्ट के बाद तक भेजा.
You did not have any document in connection with this? कोई डॉक्यूमेंट नहीं था आपके पास?
मैंने कि हम ड्राइवर हैं, हमको तो इतना ही बताया जाता है कि हाँ सामान यहाँ पहुँचा दो, साथ में रख दिया. मालिक जो बोला हम आया भी है हुजूर. मालिक रिस्पॉन्सिबल है. हम तो हमको जो गाड़ी में कहा है
ड्राइवर ऑफ द व्हीकल.
ड्राइवर.
लाइसेंस आपके नाम से है? ड्राइविंग लाइसेंस?
हाँ ड्राइवर लाइसेंस. डिस्प्यूटेड नहीं है कि हम ड्राइवर नहीं हैं.
हाँ, क्या बोलना है?
इनके पोजीशन से मिला गाड़ी से.
इनके गाड़ी से मिला. और कब से
कस्टडी है 1/12/2025. चार्जशीट सबमिट हो चुका है.
For the learned counsel proceeding on behalf of the parties, the learned counsel for the petition submits that the petitioner is merely the driver of the vehicle and some excisable articles have been recovered from his possession. From the vehicle. The learned counsel for the petition has submitted that the charge sheet has been submitted and he is in custody since 1/12/2025 and several coerced persons have been enlarged on bail. In BA number 1239 of 26, 1488 of 26, 1287 of 26. इनका नाम दे देंगे. The learned counsel for the state has opposed a prayer and has submitted that the petitioner was a driver of the vehicle and was apprehended. He has also submitted that the petition has two criminal antecedents. To which the counsel for the petition has submitted that the criminal antecedents are not under the Excise Act, but there are allegations in connection with illegally carrying coal. You have been enlarged on bail on this?
Already.
He has submitted that he has already been enlarged on bail in the cases, in the same cases. After hearing the learned counsel for the parties and considering the fact that several co-accused have been enlarged on bail and the petitioner is in custody since 1/12/2025, the charge sheet having been submitted, the petition is directed to be enlarged on bail.
From the supplementary list, under heading for final disposal, FA 37 of 2020.
This one, LCIB.
जी.
Yes. Where is it? Pass over the online. Pass over the excuse me. आप उनका अवेलेबिलिटी चेक करिए.
Under heading for orders with defect, item 3 FA 327 of 2025 filing number.
In this case, I have been filed for 2026 for the payment of deficient for my law. I already paid in this paid my law. Out of this enrollment code fee is 11,540. Out of that I have paid the 230. And remaining amount like this 11,003 my law. I will just pay after disposal of this memorandum of appeal and final order of the taxation my law. I have just mentioned in para 9 of my petition my law, or on page 6, para 9, that the interest of the revenue will be sufficiently safeguarded if the claimant appellant petitioner is permitted to pay deficient court fee after the disposal of the bill and before the execution of the final order. In this regard, there is a judgment of this honorable court, my lord, that is Ramchandra Mahato and another versus state of Jharkhand, my lord. That is para 27, my lord, last para. The registry of this court at the time of making payment, just last 3-4 lines, my lord. The registry of this court at the time of making payment shall deduct the deficient court fee
on the basis of awarded amount, the deficit court fees shall be deducted first at the time of payment of compensation. On this ground, my lord, this my petition I may please be allowed.
Heard the learned counsel appearing on behalf of the appellant. You have come for enhancement of compensation. आपको पेमेंट हो चुका है वहाँ से?
हाँ वहाँ से मिल गया। Enhanced payment जो है that was not enhanced, but payment has been drawn.
That has been drawn. No, just a moment.
Yes.
The payment has been drawn.
Payment is drawn, then filed by enhancement for.
नहीं, अगर मान लीजिए आपका एनहांसमेंट का केस रिजेक्ट हो जाता है, तो रिकवरी किससे करेंगे? एनहांसमेंट का केस अगर आपका रिजेक्ट हो जाता है, तो रिकवरी कैसे करेंगे?
Before the execution of final order of execution.
नहीं, किसका आपका तो whatever compensation was paid and assessed that you have already received.
That, but now if my case is disposal here, memorandum of appeal is disposal,
And
that
dismissed.
is enhanced.
No, suppose it
That
is
is-
dismissed. Let me just say, suppose it is dismissed. You are still liable to pay the court fees. If the case is dismissed, are you liable to pay the court fees or not liable to pay the court fees?
Not liable.
What do you mean?
Because
No, if the case, if the first appeal is dismissed on merits, are you liable to pay the court fees or not liable to pay the court fees? तब रिकवरी कहाँ से करेंगे?
that is discretionary power this honorable court matter.
ऐसा नहीं है. We are not. You see, once you say that the awarded amount has been taken by you, 18 लाख रुपए ले लिए, आपको 11,000 रुपए देने में भारी लग रहा है? I will not permit this.
But it is not certain whether that is enhanced or not. But that is a discretionary power.
डिस्क्रिशनरी आप समझ नहीं रहे. अगर कुछ पेमेंट करने के लिए बचेगा, तब ना रिकवरी होगा. अगर पेमेंट करने के लिए बचेगा ही नहीं. No, you deposit the court.
That is very much clear.
No, I will not permit this.
149
नहीं.
CPC का 149.
नहीं, आप समझ ही नहीं रहे बात. आपका ये एनहांसमेंट का केस अगर डिसमिस हो जाता है, तो रिकवरी के लिए क्या सूट फाइल करेगा स्टेट? कहाँ से देगा?
Such condition may be given.
No.
That's why I'm saying.
No. If you have received the entire compensation amount and out of that only 10,000 या जितना आपको देना है, आप पेमेंट करें. I will not permit this.
But this judgment, my lord, this reportable judgment.
Bill.
Yes, it has clearly.
हाँ, डिस्टिंग्विश करेंगे, आप चिंता मत करिए.
That is.
आप उसके बिल्कुल भी चिंता मत करिए.
That is clearly mentioned.
Just a moment.
Before the.
Heard the learned counsel appearing on behalf of the appellant. IA number 499 of 26 has been filed. नहीं, 499 नहीं.
99 is a limitation.
IA number 498 of 26 has been filed, wherein the petitioner has prayed to permit wherein the appellant claimant has prayed to permit the claimant to pay the deficit court fees on the memorandum of appeal after final disposal of the main appeal. The counsel for the appellant has submitted that he has come for enhancement of compensation, and the compensation assessed by the learned court is rupees 18,57,177, and the deficit court fees, as pointed out by the office, is 11,540. During course of hearing, he has submitted that whatever amount has been awarded by the court has already been received by the appellant. However, he has relied upon the judgment passed by this court reported in 2013 SCC Online JHAR 265, and has submitted that in the same case, the court had directed that at the time of disbursement of the awarded amount, the registry would deduct the court fees. After hearing the counsel for the appellant, This court finds that once the entire compensation amount as awarded has already been received by the petitioner, amounting to rupees 18,57,177, and in case this appeal is ultimately dismissed, then under no circumstances the courts will be in a position to deduct the payable court fees by the petitioner. The petitioner cannot assert non-availability of fund inasmuch as the petitioner has been paid amount of rupees 18 lakhs and all, and the court fees arising out of compensation, and the short court fees is only rupees ऊपर फिगर लिखे है ना 11,000 and all. Accordingly, the IA number such and such 498 is hereby rejected. The counsel for the appellant is directed to deposit the deficit court fees within a period of 1 week plenary.
2 weeks कर देना.
Okay, within a period of 2 weeks plenary. It's
Time is in the allotment. Once the time limitation is there.
ऐसे कैसे? जब तक कोर्ट फीस नहीं होगा आपका लिमिटेशन थोड़ी कंट्रोल हो जाएगा. The case is not ready.
मेरा तो 149 को दिया हुआ था लाइन में.
समझ ही नहीं रहे बात तो. रिकवरी के लिए स्टेट सूट फाइल करेगा. कोई अमाउंट अगर आपका केस डिसमिस हो जाता है तो आपके ऊपर तो कोई पेमेंट नहीं होगा आपको. कहाँ से डिडक्शन होगा? बताइए. अब आपके पास एक ही उपाय है, इस ऑर्डर को आप सुप्रीम कोर्ट में चैलेंज कर सकते हैं. ये इतने सारे लैंड एक्विजिशन केसेस हैं, सब में केस फाइल हुआ होगा. आप किए हैं, कोई और किया है? ये देखिए, ये सारे लैंड एक्विजिशन केसेस हैं, सबका पता करिए और सबको लिस्ट कराइए. ये दिस इज अराइजिंग आउट ऑफ
उसमें टाइम थोड़ा बढ़ा दिया.
कोई बात नहीं. 2 हफ्ता दे दिए बहुत. नहीं देंगे.
पार्टी को जैसे इन्फॉर्म.
कोई बात नहीं, इन्फॉर्म करने का
फाइनेंशियल कंस्ट्रेंट है.
कोई फाइनेंशियल कंस्ट्रेंट नहीं है. 18 लाख रुपए आपको मिल चुका है. व्हाट डू यू मीन फाइनेंशियल कंस्ट्रेंट? तो सब खा पचा गए क्या सब? 11,000 भी नहीं बचा आपके पास? नहीं. हम तो एक ही हफ्ता टाइम देते. एलियर केस नंबर 5 से ही एराइज कर रहा है, पहला नंबर से. ठीक है. बाकी जितने केसेस हैं कोर्ट पे लिस्ट कराइए कल.
Item 4, FA 1591 of 2025, filing number.
Yes, please.
One is sending the award to result correction.
What is the error?
It has been what it has come to me, advisor of Kalam.
Which IA is that?
I have 386 of 2026.
IA number 386 of 2026 has been filed with a prayer to send the award for necessary correction. Office is directed to send the award for necessary correction to the concerned court after pointing out the error in the award. IA number 387 of 26 has been filed for extension of time for removal of defects. बाकी सब हो गया? Why have you not paid the court fees?
We have written letter, but amount has not come to us. We are seeking time.
आपका तो order has already taken its effect. ये केस लिस्ट पर कैसा है? How this case has been listed? ये तो ऑलरेडी DFD हो चुका. कैसे ये लिस्ट में है? ठीक है, ये ऑर्डर को रिकॉल करिए. ये नहीं लिखिए. It appears that the order dated 3/12/2025 has already taken its effect. As the defects were not removed within time, including payment of fees, including payment of deficit court fees. So far as the other defect with regard to necessary correction in the award is concerned, for that separate interlocutory application has been filed. But admittedly the court fees has not been paid. Office to verify and do the name. Same करते हैं. कोर्ट फीस कैसे नहीं फाइल करते हैं आप? और आईए फाइल करते हैं तो विद इन टाइम आपको मेंशन करके लिस्ट कराना चाहिए ना. आईए फाइल करके सो जाइएगा. It has already taken its effect. We are not going to restrict that.
Item 6, FA 2148 of 2025.
Yes.
My lord, I was permission to review this case, my lord. Here is a defect of the court fee, my lord. Fees and charge to the petitioner, they will be filed. So award challenge किए थे, रुपया का जवाब
Counsel for the petitioner submits that he does not want to press this first appeal. Accordingly, this first appeal is dismissed as not pressed. Sign करिए इसमें.
Sign करके appearance में. From the daily list, under heading for hearing targeted case, item 1 WPL 1347 of 2017.
You are for the respondent. Where is the petitioner?
Small request I can make, Lord. Last time Mr. Satish Bakshi had assisted, and he is having some problem, he is not in the position. Therefore, I just pray for 2 to 3 days recommendation in this case.
Have you prepared any notes?
I have prepared note and I will give also.
You also prepare your notes. The NCR has been received.
NCR has been received.
But
If it is posted for coming Tuesday,
counsel for the petitioner submits that the matter has to be argued by Mr. Satish Bakshi, but on account of his personal reasons, he is unable to appear before this court today. He submits that appropriate note to assist this court will also be prepared if the case is adjourned. At the request of the counsel for the petitioner, holds this case on next Tuesday under the heading for final disposal. Counsel for the parties are directed to submit their short notes of argument, synopsis of argument with supporting judgments by Friday?
Yes.
By Friday. You also do the needful.
I think declared already because the presentation has been submitted or declared in Friday.
By Monday?
By Monday.
By Monday इनको बोल के देंगे और हमको भी बता के
जी जी.
नेक्स्ट पॉइंट.
Under heading for orders with defect, item 14, FA 5793 of 2025, filing number.
Yes. Council for the applicant praise for बहुत छोटे-छोटे डिफेक्ट्स हैं 250 रुपए को पीस. Praise for and is granted. Time till 1st of April to remove the surviving defect preemptively. If the defects are removed within time, post this case on 7 and the appropriate.
Item 15, FA 12515 of 2025, filing number.
Yes. You are seeking enhancement? You are seeking enhancement? Are you seeking enhancement of compensation? Are you seeking enhancement of compensation?
No. The stat reporter has reported that I will have to pay the sum of rupees 21,300 as court fee. My submission before the board is that the petitioner that will be appealed is a member of civil tribe and therefore he is unable to pay the court fee. Earlier also, in another suit here, declared for exemption of court fee has been done.
No, Mr. Dev, you just tell me. You have been awarded some compensation by the collector.
No.
No?
No, it is still pending.
Still pending. What is pending? You see, compensation awarded by collector 11,55,000.
No, my lord, pending.
It is at page number 17, 17.
This suit, it has not been paid to the jury. Paragraph 5, page 4 the time. That is not one year, suit number 7.
Paragraph 5, page 4
Page 4.
of the impugned award, of the impugned order,
No, this is not to another,
memo of appeal.
another land application.
I am not able to get it.
In that case, if there was for exemption of filing court fee, that has been allowed, the court fee was paid.
My question is very, very different. What was your case for?
It was for claiming compensation.
Claiming compensation. The petition was filed under section 30.
Claiming compensation, I have filed this appeal against the judgment of allocation of 7 of 2008. Last, I have seen moving.
You were claiming compensation under section 30.
Yes.
Right? So
My land has been required.
That's right. That is why you are here. You were claiming compensation under section 30. It means that somebody else was awarded compensation.
Yes, there was some
Dispute.
dispute.
Somebody else was awarded compensation. Now, by virtue of this particular impugned order, your claim of compensation has been rejected.
Not rejected. It was distributed between the parties.
Okay. How much
Eight
did you
persons
get?
came before the court.
How much
They
did
were
you
not-
get? How much did you get? If it was distributed, how much did you get? And whatever you have got, have you received it or not received it?
I have
If you have not received it, then I will pass a direction that before remitting, the court fees will be deducted. And if you have already received it, you have to pay the court fees. Merely because you are a member of scheduled tribe, is there any exemption?
Yes, I have exemption from filing court fee. On the ground. Earlier also in another LA case, the exemption has been granted. Court fee has been paid by the Jalsa.
By Jalsa has paid it. By Jalsa has paid it.
Yes, Jalsa has paid.
Under which provision are you claiming exemption from payment of court fees?
Because I have been member of the scheduled tribe.
You have to show me some provision, no? This is not a case filed through Jalsa. You have to show me some provision that merely because you are a member of scheduled tribe, you are exempted from payment of court fees. Show me some provision, I will allow it immediately. कल परसों फ्राइडे ठीक है आई नंबर 765 of 2026 Council for Dapilan has submitted that Dapilan belongs to scheduled tribe category and therefore he is exempted from payment of court fees. However, he has not been able to show any such provision before this court during the course of hearing. He seeks adjournment. At his request, post on time in the supplementary cause list.
Item 16 FA 110 of 2026.
Milord, office has pointed out regarding maintainability of this facility.
Yes.
Milord, in this case, what has happened? Milord, suit IMB defendant. Suit was filed before the civil judge linear division with the suit value 2,60,000. Thereafter, I filed Milord counter claim on the same property, suit. Now, as per my calculation, Milord, this suit value was 35 lakh.
In the counter claim, did you pay court
The
fees?
counter, yes.
Did you pay court fees for 35 lakhs?
Yes, 35 lakhs. Now, the plaintiff also filed an application before the learned trial court that yes, since the suit value is 35 lakh, so claim should be returned to me and court fees should also be returned to me and I may be permitted to present before the proper court. His application was allowed. Now, my lord, I have filed, my lord, the certified copy of that order on, my lord, on 18/2/2026. Photocopy, my lord, for ready reference. I have filed the certified copy of this order. It has already been filed, certified. I have, my lord, taken his entire order sheet, my lord. From there, my lord, this order has been filed. Now, kindly, my lord, I am permitted to read this order, my lord, 9/1/2025.
Then the fresh suit was filed?
Yeah, this claim was presented and the
Presented before whom?
before the learned civil judge senior division.
Okay.
Now, learned senior division taken on the record and also called for the entire records of the earlier suit.
That's right.
Now, my lord, kindly see the order dated 9/1/2025.
Yes. So what do you want to say?
I want to see, my lord, that the suit valuation has been enhanced as per the plaintiff also and the defendant also.
Okay.
Now, suit value is 35 lakhs.
Therefore, the first appeal would like.
Like, and it indicates also by from
Where is the decree? No decree has been brought.
Decree has been prepared, my lord.
Where is it?
Decree along with the judgment. There is, my lord,
No, there
error.
is no decree mentioned.
नहीं है जो जजमेंट के साथ हम लगाए फर्स्ट अपील का मेमो ऑफ अपील विद द मेमो ऑफ अपील and a separate decree was filed by us separately. At that time it was not prepared. Suit value is shown by 2,30,000.
तो ये एरर है ना
ये
decree?
इसी एरर
तो इसको भेजेंगे
भेज
करेक्शन के लिए?
यस
इसमें आइए क्यों फाइल होगा?
आइए नहीं फाइल किए माइलॉट क्योंकि माइलॉट के सामने पूरा असिस्ट करना चाहिए and one fact is also माइलॉट indicated माइलॉट that court fee is paid if my lord, can you see the last page of the decree? My lord will find in the column stamp for complaint 50. If my lord can see last page, my lord, of the decree in
Yes,
column
yes. 54,000.
54,000. And it is the suit was for 2050. So earlier maximum court fee was paid. So it should be sent out.
The learned counsel for the appellant has submitted that the suit value has been wrongly shown in the decree, and therefore the office has pointed out that the present appeal is not maintainable. We have submitted that suit was initially filed before the Court of Civil Judge Junior Division Chandel and was numbered as OS 49 of 2015. However, the plaint was returned by the order dated 9/1/2025 on the ground that the suit value was more than 35 lakhs. He submits that thereafter the case was presented before the Civil Judge Senior Division, and ultimately the case was decided, and the decree itself reveals that appropriate court fees was paid by the plaintiff. He submits that office may be directed to send back the decree for necessary correction by the concerned court. Considering the submissions, a copy of order dated 9/1/25 passed by Civil Judge Junior Division Chandel has been produced before this court.
And by the court,
Office is directed to send back the decree in original suit for correction along with a copy of this order.
yes.
Other defects?
अगर जिन्हें सभी रूट उसके बाद आ जाएगा तो हम फाइल कर देंगे.
Post on April. कोई बात नहीं, लिस्ट खत्म करनी हो क्या खत्म?
ये खत्म किया, अब ऑर्डर शुरू.
ऑर्डर्स करें.
Under heading for orders, item 17 FA 60 of 2021.
Yes. Refused. Yes, what happened? What is the office not?
I have not seen you.
आप देखिए. At the request of the council for the appellant, post tomorrow.
Yes, sir.
As per this report, my lord, it will take time because 1 and 3 has appeared and respondent number 2 has died.
Has died.
That report has
It refused RN.
एक refused भी.
Died कहाँ से?
पता नहीं. देख रहे हैं बोली नोट किया died है respondent number 2.
No such person. Refused लिखा हुआ.
उधर 2 में refused लिखा हुआ.
Respondent number SR आया है report process.
My lord,
Okay.
इसका substitution करना पड़ेगा.
Counsel for the parties are present. It is submitted that respondent number 1 and 3.
They appear.
1 and 3 has already appeared. Respondent number 2, as per office note, respondent number 2 has expired, and respondent number 4 has refused to accept notice.
The phone has received through his staff.
And
his question.
And it has also been stated that
Competent
the so far as note of process server is concerned, the notice has been received through the competent staff and the registered notice has been refused by respondent number 4. Counsel for the appellant submits that the notice upon respondent number 4 be accepted as validly served. Considering the submissions, the notice upon respondent number 4 is accepted as validly served. At this, counsel for the appellant seeks a judgment. कौन है respondent number 4? Counsel for the appellant is directed to the office is directed to forward a copy of this order to Mr. Manish Mishra, who normally appears for Messrs. Disco Limited. ठीक है? डेट बताइए कब?
Substitution will file affidavit by within 3 weeks. Because we have to take instruction that we will be.
ये आप कौन है? Respondent number 2 के कौन है आप? 2 के कौन है आप? Are you related to respondent number 2?
Yes, ma'am.
Yes.
Take instruction.
Counsel for the respondent number 1 and 3 is directed to provide the details of the legal heirs and successors of the respondent number 2 to the counsel for the appellant.
Right.
Within 1 week, within a week from today. Post on 20th April.
Right.
Item 18, FA 92 of 2022.
This case of the previous council is giving no objection. Actually, to each time for filing case of the
It is still defective. It is still defective.
I will verify.
ये एक सब्स्टिट्यूशन है रिस्पॉन्डेंट नंबर 10 का। वकालतनामा मिल गया ना आपको?
2 का मिला, बाकी का नहीं मिला।
2 का मिला है मतलब?
117 का मिला।
काफी है स्टेप्स लेने के लिए। फाइल किए हैं 117 का?
नहीं।
देखिए, जिन्होंने आपको नो ऑब्जेक्शन दिया है उनका रिस्पॉन्सिबिलिटी तब तक खत्म नहीं होता है जब तक कि यहाँ पर फ्रेश वकालत या वो काउंसिल आके बोलें कि भाई हमको अब इस केस से कोई लेना देना नहीं। He is still on board, right? IA number 3416 of 2025. The counsel for the appellant is present. He has submitted that after receiving that he has received wakalatnama on behalf of fresh wakalatnama on behalf of appellant number 1 is
7 and 8. 7.
Appellant number 7 and 8, which he undertakes to file within 1 week from now. Let notice be issued to the proposed legal heirs and successors whose details have been provided in paragraph 4 of the interrogatory application. इसमें तो पहले 3 लिखे हैं, एक तो इसमें 4 लिखे पैरा 4 में. Through speed post. Legal years and successes of late Markhanlal Agarwal hearing by filing वकालतनामा. कहाँ है ये? कौन एप्लीकेट कर रहे हैं? Markhanlal Agarwal has expired. Appeal number, अच्छा ये appeal number 10. ये appeal है? ओ अपील नंबर 10 नोटिस नहीं होगा इसमें. ये बाकी लोग क्या ऑलरेडी रिकॉर्ड पर हैं? आप चेक कर लीजिए भाई, आप चेक करिए, नहीं तो वकालतनामा फाइल करिए. फिर से द अपील नंबर 10 हैज एक्सपायर्ड एट द रिक्वेस्ट ऑफ द काउंसिल फॉर द अपील एंड पोस्ट. चेक करके बताइए, सब्स्टिट्यूशन अलाउ कर देंगे.
Item 19.
वकालतनामा फाइल है, चेक करिए.
Item 19 FA 88 of 2023.
Respondent number 4 is general public relations. Respondent number 2 is private respondent. Is the office note says that the house was not located.
The letter comes for the appeal and submits that respondent number 2 and 4 could not be traced.
Respondent number 4 is general public relations.
Okay. So far as respondent number 4 is concerned, she submits that they are general public. Notice गया था वहाँ उनको भी.
हाँ.
Take out paper publication because substituted service तो आपको respondent number 2 का करना ही पड़ेगा. Right? That would be better. She submits that she shall file appropriate petition in connection with respondent number 2 and 4. How much time do you need? Post on 20. एक का पेपर पब्लिकेशन करना है, दूसरे का भी कर दीजिए, साथ ही साथ हो जाएगा. एक ही आईए में दोनों कर दीजिए. Yes. 20.
Item 20 FA 93 of 2023.
Notice was issued on the last day to lordship on respondent number 4 to 6 lordship. Respondent number 6 is for former respondent Tata Steel lordship. The office note says that the staff of Tata Steel received it. And for 4 and 5 it says that the address was not found and is sufficient.
Also for the appeal and submits that the respondent number 6 has been served to the competent staff of Tata Steel. She submits that the notice be accepted as validly served. Considering the submissions, the notice upon respondent number 6 is accepted as validly served. She further submits that respond number 4 and 5 could not be traced and therefore the notice could not be served. She submits that appropriate steps will be taken in connection with respond number 4 and 5. Post on 20th April, 20 April, office is directed to forward a copy of this order to Mr. Manish Mishra, who normally appears for Tata Steel. Ex parte करके क्या फायदा? He appears. He is a retained counsel of Tata Steel, Mr. Manish Mishra.
Item 21, FA 226 of 2023.
Yes. Passover. At the request of the council for the applicant, post on the list.
Item 22, FA 239 of 2023.
Yes, please.
The office says that the address is incomplete. It's returned. Notice is returned Monday. 25 minutes for the 26th.
Service report has not come. 25/10.
Kindly have the office note dated 25 to 2026.
25 to 26.
25 to 2026.
There is no such office note. Oh, this one. It was sent to the concerned judgeship for service, but there is no office note with regard to that, whether the notice has been served or not served.
Because on the later part it says that the address is
Incomplete address of respondent,
because,
sir?
because your ladyship, the respondent did not even appear in the trial.
But still,
The trial was heard expunged.
Mumbai.
The registered office is in Delhi, and the other office, the corporate office, is in Mumbai.
The learned counsel for the applicant submits that the respondent could not be served as per office note for want of complete address. इसलिए क्या इतना तो एड्रेस है इसमें? Yes, so much of address is there. He submits that complete address has been provided in the memo of appeal. He has also submitted that the proceeding was ex parte even before the learned trial court. However, he submits that Section 8, Arbitration Act.
The suit was dismissed already on the ground of jurisdiction.
ठीक ही तो है. क्या है इसमें? कुछ करने को है? पब्लिकेशन करेंगे? Are you serious with this case? Section 8 का पिटीशन आपका अलाउ हो गया ना? Section 8. Suit was dismissed on account of jurisdiction. Are you serious? You are going to conduct this case? सोच लीजिए, मेरिट देख लीजिए भाई, आपका सारा रेमेडी इस टाइम बांट है. Think of it. At his request, close this case on. बताइए कब रखना है? जो मर्जी फिर पेपर पब्लिकेशन कराना पड़ेगा 2-3 न्यूज़पेपर में. एक 1.5 लाख रुपए खर्चा है उसमें. एक दिल्ली का पेपर है, एक मुंबई का एड्रेस है, दोनों एड्रेस है आपके. It involves quite an expense also. Right? एक हिंदी, एक इंग्लिश, क्या करिएगा? इनका रजिस्टर्ड ऑफिस से आप नेट से पता करिए तो सब लिस्टेड कंपनीज होंगी.
एक दिन का टाइम दे दो.
थोड़ा सोच लीजिए. हाउ सीरियस यू आर अबाउट दिस केस. Post on 30th March. Please launch.
Item 23, FA 272 of 2023.
Yes.
In this case, council on record in this case appearing through video conference. Really allowed.
Respondent number 10 has not appeared.
My lord, I am hearing on behalf of the applicant.
Yes, respondent number 10 has not appeared.
No, my lord, even in the trial court, initially we did not even include him as the defendant, stating that he is traceless. Thereafter, the defendant filed an application asking the court to direct us to include defendant number 10. Then accordingly, this defendant number 10 was included.
You have to undertake private paper publication. We will not permit it like that.
My lord may see, my lord, if my lord will see the order dated 17.08.2016, that was where the ex parte order was passed against this particular defendant, Helen Snakla. In this, it is very clear that all steps were taken. We, on multiple addresses, we tried to send the summons. Paper publication was also done, but despite that, he was
17.8.26, just a moment. 17.8?
2016.
2016. There is no such order. 2016 का order कहाँ से आएगा? 23 का first appeal. Yes?
My lord, the trial court's order.
No.
The trial.
Here you have to undertake paper publication. We will not permit this.
My lord may just see the facts of the case.
No, whatever be the facts of the case, the party is here. You have to undertake paper publication.
My lord, he never appeared.
He may not have appeared. He may appear now. Who knows? We will not permit this. रांची का प्रभात खबर में कर लीजिए. प्रभात खबर in Telegraph. You file your petition.
My lord may just see the facts once.
Whatever be the facts, he is a party. We will not permit it like that.
My lord, initially we did not even include him as a party. My lord.
You delete him now. You file an application for deleting his name. You do not know.
My lord may just see the order.
At your risk, you delete it.
My lord, all I am requesting is to just see 2 orders, my lord. Then after that, my lord may pass any suitable order.
Which 2 orders? Which 2 orders?
My lord, first, my lord may see the order dated 27 January 2016.
Page number. Page number.
My lord, I do not have the page, but it's on the records.
So?
My lord, I apologize, I do not have the page. The order dated 27.
I can't help you if you do not have your page number, you do not know where to look for. We are not going to permit this. देखिए IA number 16624 of 2024. The Learned Counsel for the appellant has submitted that this petition has been filed for hearing the appeal ex parte against respondent number 10. He has submitted that it has been recorded in paragraph 7 of the impugn judgment that Helen Lakra was impleaded as defendant number 7 in the suit by the order dated 27/1/2016, but he did not appear and therefore the suit proceeded ex parte. The Learned Counsel submits that the notices were sent at the given address, but he could not be traced. He has also submitted that since the proceeding was ex parte against respondent number 10 before the learned court, who was defendant number 7, under such circumstances, the proceeding here, we proceeded ex parte against respondent number 10. This court is of the view that if the respondent number 10 is not being served for want of proper address, the appellant is required to take appropriate steps for substituted service of notice upon respondent number 10. Accordingly, IA number 16624 of 2024 for proceeding ex parte against respondent number 10 at this stage is rejected. If the respondent number 10 is rejected at this stage, counsel for the appellant may pose this case on 30th March.
My lord, in the order dated 27/1/16, in the order dated 17 September 16, it has clearly come on record that the notices were sent on all the addresses given by the defendant, and multiple addresses were given by the plaintiff. But in none of the addresses this particular defendant was traceable. That is why the
you go for substituted service of notice.
Obliged.
Item 24, FA 308 of 2023.
Municipal last day, notices were directed to be issued to the respondent as per the office plus respondent numbers 1, 2, 4, 6 and 7 have appeared through Makalakama. Respondent numbers 3 and 5 have died, and respondent number 8 NHA received by competent staff.
The learned counsel for the appellant submits that respondent number 1, 2, 4, 6 and 7 have already appeared through Wakalatnama. So far as respondent number 8 is concerned, the notice has been served to the competent staff. He submits that respondent number 8 is the project director NHAI. He submits that the notice upon respondent number 8 be accepted as validly served. Considering the submission, the notice upon respondent number 8 is accepted as validly served. As per office note, respondent number 3 and 5 have expired. The office note was prepared as back as on 18/9/2025. Accordingly, the proceeding has updated in connection with respondent number 3 and 5. Counsel for the appellant seeks the judgment. Post on 30th March. 30th March. 30. Office is directed to forward a copy of this order to MSVP Tokno, who normally appears on behalf of National Highway Authority. Yes, on 30th. Sufficient time. It has already awaited.
Item 25.
30th की जगह next week कर दीजिए. On 7th.
Item 25, FA 75 of 2026.
At the Passover for today means tomorrow. At the request of the counsel for the petitioner, post this case on next Tuesday.
Item 26, FA 88 of 2026.
IA number 1507 of 2026 in first appeal number 88 of 2026. The learned counsel for the appellant has submitted that the petition has been filed for confirmation of delay of 314 days in filing the memo of appeal. Issue notice to the respondents on the interlocutory application seeking confirmation of delay to speed post, for which requisites be filed within a week. Office is directed to track the speed post delivery. Post this case on 8th of April and appropriate heading.
Appearance.
आपका एक एरर उसमें रह गया, वो जो प्रेयर है ना उसमें 317 नहीं लिखा, वो 28 रह गया. At this counsel for the appellant has submitted that in the petition seeking confirmation of delay, though appropriate correction has been made in paragraph 1 and other places in the petition seeking confirmation of delay, but in the prayer portion, the necessary correction has been inadvertently not carried out. She seeks permission to carry out the correction in the prayer portion of the interlocutory application during the course of the permission is accorded. इसको ठीक कर लीजिए.
Item 27 FA 200 of 2026.
Yes. IA number 2410 of 2026. In FA file number 14707. Number पढ़ गया आपने ना?
number पढ़ गया.
In FA number 200 of 2026. Counsel for the appellant has submitted that there is delay of 48 days in filing the appeal. Issue notice to the interlocutory application seeking confirmation of delay. How many respondents are there?
17.
To the respondents through speed post, for which requisites be filed within a period of 15 days. Office to track speed post delivery. Post on 27th.
Okay.
Under heading for admission, item 28 WPL 3 of 2017.
अच्छा, not before.
Item 29 FA 71 of 2026.
This appeal has been filed now against the judgment and decree dated 88 Lords, I just want to indicate that one first appeal 190 of 2025 has also been filed because it has been filed by the other defendants.
Yes.
So in that Lord, the notices have also been issued.
What is the date?
Date?
Date in that case.
Date in that.
Date check करके बताइए. First appeal 190 of 25.
Notices have been issued Lord, and we have also appealed.
First appeal 190 of 25.
जी.
Who are the appellants in this case?
Lords, here the appellants are
Who are the appellants in that case?
in that case. The appellants are Lords Shiva Gupta and Lords Manju Gupta. They are defendant number 3.
Shivam Gupta and Manju Gupta. How
Yes.
about others?
Lords
My lord, the respondents are there, my lords. I am respondent number, my lord, 2 and 3, my lord, in that second number 190.
That's right. Also, for the appellant has submitted that arising out of the same interim judgment, FA number 190 of 25 has been filed, which has been admitted and notice has been issued, and the next date in the case is 29th of April 2026. To service that the present appellant have already appeared in the said proceedings. He has also submitted that this appeal may be formally admitted and tagged to the same case. Admit. Issue notice to the respondents through speed post. The notice upon respondent number 1 should be issued at both the addresses given in the name of applicant. Office to track speed post delivery. The requisites be filed within a period of 15 days from today. 15 days. 1 week no data. Within a period of 1 week from today. Post on 29/4/2026. Tag this case along with FA number 190 of 25.
Item 30, FA 85 of 2026.
I only correct for not.
Why not today?
because रात में जल जाना पड़ा हम लोग को ये रमजान वाले
तो एडमिट होगा ना, इसको करना क्या है?
एडमिट कब दिए
कुछ है क्या इसमें? डिफेक्ट भी है क्या?
नहीं
नहीं है ना डिफेक्ट? Also further appellant discussed. Admit, call for records from the concerned court. Issue notice to the respondents through speed post, for which requisites be filed within a period of 1 week from today. Post on 29th April, awaiting service report, office to track speed posting.
Item 31, FA 199 of 2026.
Issue notice to the respondents. Or admits, call for records from the concerned court. Issue notice to the respondents, for which requisites under speed post be filed within a period of 1 week. Office to track speed post delivery, post on 29th of April. Passover.
Passover case from supply list, item 2, FA 37 of 2020.
इनका एक और चार्ट था ना? Plain.
Yes.
कॉन्ट्रैक्ट का रिजॉइंटर काउंटर फाइल हुआ था? Written statement to the contractor? Was it filed?
Yes.
Yes, I have it. Yes, please. Mr. Gupta, the court has not declared your title. Your title has not been declared, nor you claim any relief to that effect.
Yes, it has not been declared, but the essential facts which were there before the court were that the admitted owner was Ishtiaq Ali. He executes a sale deed. The plaintiff challenges that and that suit fails. So the consequence would be that I am the owner of the property because challenge to my sale deed has failed.
In another suit, the court has decreed.
I was not required to seek a declaration because there were chain of event. Ultimate last owner transfers the property by registered deed to me in the year 2010.
The court has held that the state is the paramount owner and the vendor was only in illegal possession of the property. And against the state, when the suit was filed, the adverse possession was declared.
But ultimately, it was held that my suit was ultimately decreed. The previous suit was decreed in terms of what was prayed for.
What is that?
Prayer was for declaration of plaintiff number 1's title.
Where is the decree of the previous suit?
Yes.
Suit number?
Suit was 2004.
Title suit number?
24 of 2004.
24 of 2004.
Exhibit H.
Exhibit H. Yes. Who were the parties in that title suit?
Ishtiaq Ali was plaintiff number 1 and Nutan Minj was the plaintiff number 2. This would be clear from the decree which is marked as Exhibit H by 1.
The plaintiff was this Ishtiaq Ali and the defendant was
State of Jharkhand. In the previous suit we are, this is related to the previous suit.
That's right.
Which was against the state of Jharkhand.
Okay, it was against the state of Jharkhand.
Yes.
Okay.
Both the Ishtiaq Ali and Nutan Minj were parties to the previous suit where Ishtiaq Ali was the plaintiff number 1 and Nutan Minj was plaintiff number 2.
Okay. Nutan Minj is the daughter of Ishtiaq Ali.
No, she was the wife of, second wife of Ishtiaq Ali.
Okay. Ishtiaq Ali.
And this relationship is not in this.
And Nutan Minj. Second wife. They were party to the suit. And what happened in the suit?
Yes, the suit was dismissed by the trial. And the vendor of the first sale deed, Jwala Prasad Singh, he was already recorded in illegal possession since the year 1960. And that ultimately led the appellate court to hold that the plaintiffs had been able to prove their case of adverse possession.
So how in the impugned judgment it has been written that adverse possession of Iftiaq Ali was declared by a competent court?
Because the suit itself was for declaration of right title interest of plaintiff number 1, Iftiaq Ali. This was the prayer, not prayer that for declaration of Nutan Main's title. She was only pleaded as a party because her deed existed in her name and she was the wife. But the essential declaration which was sought was for declaration of plaintiff number 1's title. And
So,
this prayer,
so just a
this
moment. Whose adverse possession has been declared?
yes, and that I'll come.
And where is that finding?
First H by 1, the degree where my relief which was claimed in that suit, that has been quoted, that may kindly be seen.
I've seen that.
What was the relief that had been claimed?
I've seen.
For a decree for declaration of title of plaintiff number 1.
Yes.
For a decree of declaration of title of plaintiff number 1, Sayyad Ishtiaq Ali over the Schedule A property and for decree so and so. So, essential prayer itself was only for declaration of Sayyad Ishtiaq
But the
Ali's.
judgment is saying that the suit is for declaration of title with respect to suit property by way of adverse possession. The judgment is saying that. The main judgment.
Yes.
It is not
It
just
says
for
by-
title, but by way of adverse possession. That is also recorded in the judgment. How do you
Yes, but my
reconcile?
prayer itself was this only for declaration of title of plaintiff number 1 and what was allowed by the appellate court, this may kindly be seen. Ultimately, what was allowed?
This was subject matter of appeal.
Appeal, yes, title appeal.
What
Because
was
the
allowed?
suit was dismissed by the trial judge. This went in appeal
Yes.
and in appeal, the concluding portion of the appellate court's order may be seen. This is Exhibit G. Title appeal number 23 of 2007.
Yes.
I'll only come to what was actually granted by the appellate. The trial, it is there in para 16. Thus, in view of discussions made above on the basis of materials on record, it has to be concluded that the plaintiffs succeeded in establishing the fact that they protected their title over the suit land by way of adverse possession and as such are entitled for a decree as prayed for. This is the most important line. And as such are entitled for a decree as prayed for. So prayer itself was only for declaration of title of plaintiff number 1.
We will not
And that was
interpret
allowed.
this. Are we here to interpret this judgment now? Yes.
Pardon?
Are we here to interpret this judgment now?
No, it is not. I'm not. I'm just saying that what was prayer was something else, and that prayer was allowed. And now the question is whether I have Sayyad Ishtiaq Ali when he executes a deed of sale in my favor. Then what would be the effect of that deed of sale? Because Nutan means, although the initially property stood in the name of, was purchased in the name of Nutan means in the year January 1985, but after 5 months he executes a registered deed of release in favor of Ishtiaq Ali, saying that he is the actual person who is the owner of it. And this particular release deed is squarely covered by one Supreme Court judgment where the Honorable Court has held that where a person who is the ostensible owner, he executes a release deed in favor of some other person, saying that he is the Benamidar, he is the actual owner of the property, then the such person has the absolute right, title, interest over the property.
Which is that?
Yes. This is report Shankara Ali.
Give me just 2 minutes. Give me 2 minutes. The Learned Counsel for the Appellant has referred to the earlier suit filed by Syed Ishtiaq Ali and Dr. within bracket Mrs. Nutan Ali alias Nutan Mills, who is the second wife of Ishtiaq Ali, and submits that title suit number 24 of 2004 was filed seeking a declaration of title only in favor of Mohammed Syed Ishtiaq Ali. The suit was dismissed and the appeal was allowed, and the learned First Appellate Court in title appeal number 23 of 2007 has held that the plaintiffs succeeded in establishing the fact that they had perfected their title over the suit land by way of adverse possession, and as such they are entitled for a decree as prayed for. The Learned Counsel submits that it was only Ishtiaq Ali who had prayed for a decree, a decree seeking his declaration of title, and therefore the decree arising out of title appeal number 23 of 2007 is only in connection with the suit, only in connection with title of Ishtiaq Ali. He submits that Dr. Mrs. Nutan Ali, alias Nutan means was made party in the proceedings, inasmuch as Ishtiaq Ali had purchased the property in the name of Nutan Ali alias Nutan Mills, while registered sale deeds, 2 registered sale deeds dated 10/1 सेल डीड्स है ना, इन्होंने खरीदा तो इनके नाम से था ना,
खरीदा था, सेल डीड था और फिर रिलीज थी।
सेल डीड का डेट बताइए।
10/1/1985।
2 registered sale deeds dated 10/1/1985 and 16/7/1960.
Yeah. That was the original sale deed.
Okay.
By which Jwala Prasad.
2 sale deeds dated 10/1/1985 from Jwala Prasad, and Jwala Prasad had obtained the property by virtue of a registered deed dated 16/7/1960. He submits that Nutan Means has executed deed of release/relinquishment dated
it is in the month of May 1985.
in the month of May 1985 on 25/1985 in favor of Syed Ishtiaq Ali. The Learned Counsel submits that what was ultimately declared in title suit number 24 of 2004 read with title appeal number 23 of 2007 was the adverse possession of Ishtiaq Ali and not the adverse possession of Nutan Mills. He has relied upon the judgment passed by the Honorable Supreme Court. बताइए.
Shankara Ali.
Citation, please. Citation.
1996, volume 7, SCC, page 55.
Page 55, para number?
Para number 4 and 5.
Para 4 and 5. He has relied upon the judgment. He has relied upon the judgment passed by the Honorable Supreme Court reported in bracket 1996 bracket close 7 SCC 55 para 4 and 5 to submit that if the Benamidar executes relinquishment deed in favor of the person who actually bought the property, then the property would pass on to the actual owner of the property.
Yes.
कहाँ है तो फिर क्या लेके
अरे वो दिए हैं
वो नोट्स में साइटेड है 8/20
नहीं दिए उनको टाइम नहीं मिला अभी जूनियर को ऐसे तो कैसे ही होगा इसका मंगाइएगा 96/7 SCC 55. Yes, next. Further, what do you want to say?
Yes. And yesterday there was one query put up by this honorable court. To answer that, it would be better that if we this Supreme Court judgment, identical case was there before the honorable Supreme Court, and this judgment would substantially cover my case.
Which judgment is that?
This is 2014, volume 11, SCC, page 664.
Para number?
Para is only facts are important, but main paragraph would be para 11.
The Learned Counsel has submitted that in the judgment reported in bracket 2014 bracket close 11 SCC 664 under identical circumstances under similar circumstances as involved in the present case, the relief was granted. He submits that the present case is squarely covered by the said judgment. However, the ratio of the he has also submitted that the facts of the said case be also read, but the ratio of the judgment has been given in paragraph 11 of the report. 13.
Yes.
Para 13 of the report.
Can I read it?
Yes.
This was a case, if your Lordship would kindly see the first where genealogical table has been given. The first para 1 page 2. Yes. So the case was the Chidambaram had held the property and ultimately the property came to C.P. Sundaramurthy. He executes a deed in favor of his own sister Jagdambar. And this Jagdambar, she allowed daughters of Sundaramurthy, that means Shanti and Padmavati, to live with her. That means to live with Jagdambar. Although Sundaramurthy had already transferred the property to Jagdambar. Now she allows this Shanti and Padmavati to live with her. Now they started creating trouble. So two suits were filed. One suit was filed by Jagdambar seeking mandatory injunction for eviction against Shanti and Padmavati, and another suit was filed by Shanti and Padmavati claiming that because the property belonged to Sundaramurthy, Therefore, they each had 1/3 right over the property. The matter ultimately, the trial court decreed the suit. The appeal was also dismissed, but partially the High Court had allowed the appeal on some other ground. That is being now discussed. That fact would be now para 13. I may now be allowed to read. From the narration of events and finding of the court as noted above, the admitted position which emerges on record is that settlement deed dated 25/4/1949 executed by Sundara Murthy in favor of his sister Jagdambal is found to be genuine. The courts have rejected the challenge of the respondent to the said settlement deed. This finding has become final. Another finding which has attained finality is that Jagdambal had subsequently purchased the leasehold property from temple authorities and had become absolute and exclusive owner of the said property. There is thus no question of inheritance of this property by respondents as daughters of Sundara Murthy. Since Jagdambal was found to be absolute owner of the property, the possession of part of this property with the respondent has to be permissive. This is important. This is the line on which I am relying. Since Jagdambal was found to be absolute owner of the property, the possession of the part of this property with the respondent has to be permissive, as rightly found out by the trial court. If it is not their case that they were inducted as tenant or in any other capacity which would confer upon them any right to stay therein. On the contrary, the case put up by them was that they are entitled to inherit 1/3 share each in this said property by virtue of succession, which is found to be baseless scheme. On these facts, we are of the opinion that the trial court was right in passing a decree of mandatory injunction in a suit which was filed by Jagdambal. The list between Jagdambal and respondent, it is only when during the pendency of the appeal Jagdambal died, the present appellant was brought on record in substitution of legal heir as her legal heir. It is in the appeal the High Court was concerned with the validity of judgment and decree passed by the trial court wherein Jagdambal was the plaintiff. After dismissal of the appeal number so and so, the High Court should have dismissed the other appeal, that is so and so, as well. Inter se right of appellant herein and respondent as sisters was neither an issue or nor and so and so. Notwithstanding the above, we find that the High Court has relegated the parties to fresh proceeding on the premise that there is a dispute over title that needs to be determined, for which appropriate suit needs to be filed. These observations of High Court, there is dispute over title, is clearly erroneous. So far so good, it would mean that the suit which was decreed by the trial court in favor of Jagdambal was rightly decreed and High Court could not have upset the decree so and so. And after 2 lines, thus she had right to file mandatory injunction seeking to evict the respondent herein who were in permissive possession. However, Jagdambal has since passed away and question of inheritance of property of so and so is also so. So entire fact, the Honorable Court would find that once the ownership is, the challenge to the ownership of mine is fails, then the person who is in possession, I have a right to seek.
See, Jagdambal had issued a legal notice asking them to evict. Right? She had served a legal notice asking them to evict. So I was looking for that notice. What is the mode and method of issuance of such a notice? Under the Easement Act. As I could see, it would come under the Easement Act and not under the...
Let us assume that Easement Act is what
No,
would
by
be,
principle
because
would be there if the Easement Act is not there.
I'll show that also.
Easement Act
kindly the relevant portion of Easement Act may kindly be seen. Because what is actually a license? License is defined in section 52. Because nowhere else the license word has been defined. So license is defined where one person grants to another or to a definite number of persons a right to do. Section 52.
Yes.
License defined where one person grants to another or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor something which would, in absence of such right, would be unlawful, and such right does not amount to an easement or an interest in the property, the right is called the license. That means the property belongs to me. I allow certain person to do something which, in absence of such permission, that would be illegal. That would be license. That means he may do something which my permission only. And then the relevant portion again is the grant, section 54. Grant may be expressed or implied. The grant of a license may be expressed or implied from the conduct of the grantor and an agreement which purports to create an easement so and so may operate and create a license. Then the another relevant portion is 61.
Yes.
Revocation express, it can be expressed or implied. The revocation of a license may be expressed or implied. And illustration would clarify this. Illustration, what it says, illustration of section 61, it says, may I read the illustration that would clarify. A, the owner of a field grants a license to B to use a path across it. A, with intent to revoke the license, blocks a gate across the path, the license is revoked. That means nothing written is required to be given. By action also, this license can be revoked. And explanation B also says, the owner of the field grants a license to B to stack hay on the field. A lets or sells the field to C, the license is revoked. That means even by action it can be done. Nothing in writing is required to be given.
But appropriate time is required to be given to remove the.
Yes.
That's right. Now you tell us that on what basis do you say that the plaintiff was a licensee?
Plaintiff, because I say I have twofold concern. First, I must concede to the fact that I have the 2-3 portions I have said that the property belonged to Ishtiaq Ali and he had allowed or granted a license to Nutannis to stay over the property. But the building had been constructed by Ishtiaq Ali and the entire, obviously he had absolute right over the property. But he had allowed Nutannis to stay over the property and subsequently when the property was transferred by Ishtiaq Ali in favor of the defendant number 1, that now she
that
became a licensee of the
that
defendant.
transfer was by which deed?
Transfer?
Transfer to defendant number 1. By
Yes,
deed date.
by in 2010, the transfer was in the year 2010 and that was the subject matter of challenge. That has been brought by plaintiff person.
So this deed was
Exhibit 7.
Exhibit 7.
Exhibit 27/4/2010.
This deed was under challenge in the suit?
Yes, yes. In the instant suit, the present suit, the plaintiff filed a suit making twofold, various reliefs, where her first relief she claimed was for declaration of her right, title, and interest over the suit property. The second relief that was claimed was for declaration that the deed was null and void, and for also cancellation also. But essential prayer was for declaration that it was null and void. And the said suit ultimately is dismissed and no appeal is there.
So therefore, what
So
what survived was the deed dated 27/4/2010.
yes, yes. So therefore, if my chain is absolutely complete because Jwala Prasad Singh purchases a property in 1960, he transfers it in the year 1985, January 1985 to Nutan Mains. Nutan Mains executes a release deed where she very clearly mentions in the release deed that the entire concession amount was given by Ishtiaq Ali, and Ishtiaq Ali is the actual owner of the property, and therefore I am executing this deed of release in favor of Ishtiaq Ali, and he is the actual owner of the property. Now Ishtiaq Ali executes a sale deed in the year 2010, and the challenge to that fails. The declaration of
The
plaintiff's
learned
right
counsel
and
for the
dwelling.
appellant had submitted that the suit was filed seeking declaration of right, title, and interest of Newton Mins and the registered deed of transfer dated 27/4/2010 was also challenged to be null and void. The same deed was exhibited as Exhibit 7. He submits that the suit was ultimately dismissed. The learned counsel submits that what survived was the sale deed dated 27/4/2010, which was executed by Ishtiaq Ali in favor of defendant number 1. He has also submitted that Newton Mins was a licensee under Ishtiaq Ali, as she had already transferred, had already executed a relinquishment deed in favor of Ishtiaq Ali, and she herself stated that she was the benamidar with respect to the property, and this was done by virtue of a registered deed of the year 1985 itself, and consequently the title was exclusively with Ishtiaq Ali, who transferred it in favor of defendant number 1 while registered deed dated 27/4/2010. Consequently, Newton Mins became a licensee under defendant number 1, and upon revocation of license, she was to be evicted, for which the counterclaim was filed, but the counterclaim has been dismissed. He has submitted that though the Easement Act 1882 does not apply, but the principles of Easement Act does apply, and for that purpose he has submitted that Section 52 defines license and Section 61 deals with revocation of license, and revocation of license can be by action also. For that he has referred to the illustrations under Section 61 and has submitted that no written notice as such is required. He submits that it has been stated by the defendant that they revoked the license of Newton Mins but still she did not evict the property, and consequently the counterclaim was required to be held. Okay? Yes, respondent.
Our suit was dismissed. We have not challenged it. It's an admitted fact. Now, Lord, this appeal confirms to the counterclaim which has been dismissed. If you admitted facts of the cases, though we claim that I initially purchased it. I miss my mother who has died during the pandemic.
In your name?
The original Nutan.
In the name of your mother, the property was purchased by Ishtiaq Ali.
It is not by Ishtiaq Ali. I say it is from my income. Ishtiaq Ali says that the defendant says it was purchased by Ishtiaq Ali through his income, and I was a benefactor. But Lordship, the judgment of the year 2004, whereby Lordship, the decree our title was decided by the appellate court on the basis of adverse possession, neither on the basis of the sale deed issued executed by Jwala Prasad, nor on the basis of Lordship any other document. They said that we had continued in possession.
Whose adverse possession was declared?
Adverse possession of both the plaintiffs.
What was the relief in the plaint?
Lordship, that is what their argument, but kindly come to the appellate judgment.
Yes.
Lordship, appellate judgment, the operative portion is para 16.
Yes, please read it.
Thus, in view of the discussions, in view of the discussions made above, on the basis of the materials, it has been concluded that plaintiffs succeeded in establishing the fact that they perfected the title in the suit by way of adverse possession.
आगे बढ़िए.
And as such entitled to the decree prayed for.
What was the decree prayed for?
Yes, I understand decree was prayed for was the decree declaration that plaintiff number 1 is the owner.
There was no relief in the suit.
Yes.
That plaintiff number 2 was occupying the property by virtue of adverse possession. That was not the relief.
That is a finding given.
So that's right. We will see the decree, no?
You will see the finding also. Judgment cannot be ignored, Your Lordships.
You see, a person who does not claim adverse possession.
But the court declares.
How?
So this has become final.
Maybe it has
This
become
part
final.
was open for any party being agreed to challenge that. No, why it has been declared that both the plaintiff.
Why will they challenge it? They are happy with it.
Therefore, plaintiffs, both the plaintiffs succeeded. They perfected their title. They means I and the other co-plaintiff both. This is one. Second, Your Lordships, there is no declaration sought that I am a licensee. So I cannot be presumed to be a licensee. I was the thirdly, Lordships, the evidences which has been recorded from or led from our side proof, though there was no issue, there are issues, no issues to Lordship that who constructed it, but we had led evidences that I was a practicing doctor and I had constructed the house. I have also stated in my evidence that I had taken note. Lordship kindly come to my evidence.
They are governed by Muslim law.
Huh?
They are governed by Muslim law.
So I am governed by Muslim. I continue to be the Muslim.
I do not know.
No, we are stated in the plain.
Right.
My faith Muslim. And my husband, I am not governed by Muslim law. I was a tribal, and my husband was a Muslim. I have stated. Lordship, can you come to my evidence? I beg your pardon. It doesn't.
You see, the transfer by way of registered deed dated 27/4/2010, which was challenged by you, has been negated.
I understand, and I have not filed an appeal. That also I understand. Because Lordship, the original plaintiff.
So consequently, what remains as valid, is the Exhibit 7. And if Exhibit 7 is valid, who is the owner of the property?
If Exhibit 7
is valid, Then who is the owner of the property by virtue of Exhibit 7?
Exhibit 7, Lordship will have to first see whether he was the absolute owner of the property. If he was the co-owner of the property, then
See,
he can transfer.
You are entering into the legality and validity of Exhibit 7, which you have already lost.
A person cannot claim a better title than his vendor. But if there is a declaration by a civil court saying that we both are the co-owners, then Lordship, only to the extent of his share he could have with Lordship. That is the best argument they
No, you see, you cannot, once you challenge the deed.
But I challenge the deed. I do not succeed. The deed is a validly executed document. But the deed can convey only.
Deed transfers the entire property.
But it can convey the vendor. But that has not been
It is
decided
a
by the
counter
court.
claim. You see.
The counter claim, can we see the counter claim first then?
No,
What
we'll
is
see the counter claim. There is a deed which transfers the entire property.
I challenge a deed, I fail. Conversely, it does not mean that the deed is declared to be valid. I failed to show that the deed is an invalid document. But there is no finding that the deed conveys entire title, and not there is a declaration, sir, that the deed conveys actual right, title and interest over the property to the defendant. If there is a declaration that I and the co-plaintiff in the earlier suit both have jointly acquired title by virtue of adverse possession, one of the parties executes a sale deed to the entire property, which cannot convey the title of the entire property to the other side. One. Two, if your Lordship sees the deed also. Lordship, because there was no declaration sought that I have perfected my title on the basis of the deed. Lordship, the counter claim was made on the assumption that I am a licensee. There cannot be any assumption that there has to be a declaration that who I am. Unless my status is determined as a licensee, Lordship will kindly see the counter claim first before coming to the evidences.
There is one more question to it. Please move on. What is the consequence of your relinquishment deed executed in the year 1980?
Yes, it has no consequences for two reasons. One, which has been assigned by the trial court, that my right got perfected or crystallized only on completion of 30 years of adverse possession in the year 1990. Prior to that, when I did not, no right was crystallized in my favor.
You are claiming title on what basis? As per your plate? What is the basis of your title? Adverse possession?
No, I claimed my title on the basis of the original sale deed executed by Jwala.
In your favor?
In my favor. Now coming to the deed of relinquishment.
That's right. You are claiming title on the basis of original sale deed executed by Jwala Prasad in your favor, in your name,
yes.
Right? And admittedly, you executed a relinquishment deed
in
favor of
of my husband.
Your
Lordship, my husband.
What is the consequence of that?
Yes, Lordship, under law, Lordship, that because that relinquishment conveys my right title interest in favor of my husband.
Whatever
I
your
am a
right.
tribal, my caste certificate has been exhibited. Lordships, if no permission was taken, Lordship,
That is not
transaction
the
is
case. Deputy Commissioner is not a party here. Is he a party?
Yes, he is a party in this
What
case.
does he say?
He does not say anything about this present. Lordships, the transaction took place in 1985. Law requires that your Lordships, any transaction of any matter, be it lease, be it deed, be it will, be it gift, any type of Lordships conveyance requires a prior permission of the Deputy Commissioner if I am a tribal. And Lordship, no such permission was taken. That conveyance is hit, your Lordship.
You are not a Khatiyani Rayer, are you?
It is not required.
The property belongs to the state, not you. That is the finding. That the property belongs to the state and some adverse possession was declared.
Any right title interest which I have. Either it has not conveyed anything because I was not having anything at that time.
Are you claiming title or you are claiming adverse possession? Or you are claiming both?
Our claim was we were claiming title through the deed executed by Jwala Prasad, and we say defect if any because our pleading in that case was also that there was erroneously recorded in the name of state, and the pleading was defect, if any, got perfected by your adverse possession because we were in possession containing adverse to the interest and to the notice of the state, and state records it, even records in the record of right of my predecessor in interest that he is in illegal possession, then your lordship, it becomes an adverse. The title was decided on the basis of adverse possession. Now, if we
Title was not decided on the basis of actually who is the title owner of the property. Title was decided on the basis of adverse possession
adverse
only.
possession, yes. So if adverse possession, which has a great finality, therefore I argue, if adverse possession, then also I became owner or my rights crystallized in the year 1990. After expiry of 30 years, not before that. So any documentation made before crystallization of my title is a nullity. That is my first argument. Second argument
No,
is
just a moment. Any declaration made prior to
crystallization of
your right of adverse possession is a nullity.
Nullity.
From where do you say this? It is your submission? Is it based on some provision of law? Is it based on some judgment? Or it is just your submission?
I come to the judgment, but I cannot convey a right or title better than what I have. So if I did not have any title in 1985, but that is a settled principle of law, n number of judgments are there, that a vendor cannot convey a better title than what he has. In 1985, if I did not have any title, because ultimately the court held that not by the virtue of deed of Swallow Prasad, but by virtue of adverse possession I become the owner. Then I had nothing to convey in 1985.
Possession can also be conveyed through a registered deed.
Ultimately, Lordship, that registered deed.
And that is why the Supreme Court says that even the total dispossession period, even if there are intervening,
if I have any interest
just
for
a
that
moment, you hear what I am saying. If there are intervening sale deeds also, then the entire period covered by all the sale deeds is to be considered for the purposes of considering adverse possession.
Now, Your Lordship, the restriction under section 46.
You don't shift from one.
Yes, I am coming to that.
We will deal with section 46 separately.
Yes.
We will deal with section 46
Both are intermingled for that reason.
It
if
can't
your
be
Lordship says, yes, I am coming to it. Lordship, if your Lordship says that whatever, if the possession is also right which I could have conveyed, Lordship, even that requires a permission because can you see the language of section 46. My first argument is I had nothing crystallized in my favor. Suppose the Lordship says that no, the possession itself was a valuable right which was conveyable right, then that also required. My second argument is, in reply to that is also right which was required to be conveyed only with the prior permission of the Deputy Commissioner. Because the language used in section 46, because both are intermingled here, so both cannot be segregated. Is no transfer of rayat of his right in his holding or any portion thereof. So if I had any right over that property, also 85 deed could not have been, cannot be declared to be a valid documentation in absence of required documentation.
You are
No, Lordship, can you come to your Lordship? The pleadings first. Lordship, can you see what is the counterclaim of the defendant? Lordship. Contact limits. Para 11 information.
I find written statement.
Just
Then
yes.
I've seen the-
Doctor will see the written statement.
I've seen the written statement of
Yes, Doctor will
written statement of counterclaim.
Yes, after para 34, the counterclaim starts.
Written statement come counterclaim.
Yes.
Okay.
Counterclaim starts from para
34.
para 34.
Sorry, para 24.
Para 34. After para 34.
Yes.
It is one fresh paragraph in that.
Yes.
The suit property was acquired by Sayyid Mustaq Ali, father of the defendant and husband of the plaintiff, out of his own money. While purchasing the property, he got the sale deed executed in the name of his second wife, Dr. Nutan Ali, in 10/1/1985, registered in such and such. Also, this document was not held to be a valid document of title by the appellate court. Despite the fact also, I could have argued, but I am assisting the court on the basis because we are bound by the 2004 judgment. In order to avoid confusion regarding the title of Sayyid Ishaq Ali over the property, plaintiff executed a deed of release in favor by registered deed of release bearing number such and such dated 20th May 1985 by the plaintiff acknowledging the right, title and interest and possession of Sayyid Ishaq Ali. Actually, if the first document is held to be valid, your Lordship, conveying a title in my favor, then this document, in absence of Lordship compliance under section 46, is a nullity. This is our argument, this is our pleading. During the lifetime of Sayyid Ishaq Ali, the plaintiff, being the second wife, was allowed to live with him on leave and license and to run her clinic on the ground floor on the leave and license of Sayyid Ishaq Ali. Same portion was in occupation of the tenant paying rent to Sayyid Ishaq Ali. Okay, I'll pause here for a moment. A wife residing with a husband cannot be a licensee when there was no strained relationship between them. Sayyid Ishaq Ali, who was absolute owner of the suit property, right from the beginning purchased executed a sale deed in bearing sale deed number such and such and registered in the area of registration office such and such in favor of defendant. And since then, the defendant had acquired right, title and interest and possession over the same, and plaintiffs are living in a suit property on leave and license of the defendant along with her children. There is no evidence to that. Sayyid Ishaq Ali has died on February 2011, Lordship, and since then the said plaintiff is acting adverse to the right of the defendants, as after the death of Sayyid Ishaq Ali, plaintiff was asked to vacate the suit premises. Defendants stay in outside India. Lordship, para 4, there is no such notice. Defendants stay out of India in absence of his mother Mehrun. For Nisa first wife, she is the mother-in-law of defendant and other relatives are residing for performing religious rights of defendant Sayyid Ishaq. Defendant is the son of Sayyid Ishaq Ali through the first wife Mehrun Nisa. For some time past, before death of Sayyid Ishaq Ali, Mehrun Nisa was residing in her native village. She came to Jamshedpur to perform the rites of Sayyid after his death and was residing in the Supreme. Sayyid, the license was revoked by the defendant on 28 February 2011 and orally communicated to the plaintiff requesting it to vacate within 15 days. In spite of that, this has shown from the cross-examination of it, this is the wrong statement. In spite of requests made by the defendant, the plaintiff failed and neglected to vacate the suit premises within 15th March 2011 and gave threat to the defendant that she is in touch with superior police officer and other local leaders and at any point of time she can throw the above persons from the house. On 26/3/11, the family members of defendant have been illegally dispossessed by the plaintiff with the help of local police elements, and since then, plaintiff is in possession of the suit property, hence this counterclaim for recovery. Plaintiff, if they were wrongfully evicted on 26/3/11, no separate suit filed, no notice given. Plaintiff has got in no manner right to interest in this property such as. Now, can you see the relief sought for? He has not sought for any declaration. A decree for recovery of possession from the premises described in schedule of the plaint and this got contract. So without seeking a declaration, para 11. Now your lordship, this is the first part. Second, your lordship take into consideration the sale deeds are on record. Lordship, the property in which I came in possession by virtue of a sale deed executed by Jwala Prasad was a vacant land as mentioned there. Admittedly, a house was constructed over it. Plaintiff claims, your lordships, that my father constructed it. No document, no source of money has been provided. I, to the contrary, have laid evidence, lordship, tested in cross-examination, that your lordship, I had taken loan, I was a practicing doctor, and from my funds, I had constructed the house. Now coming to the evidence, your lordship.
You are by faith Christian.
I am by faith Christian. That your lordship is fine.
Even by persons by faith Christian can seek the protection under the Children Applicants Act.
But if I am a tribal, I can seek, your lordship. My caste will not change. Lordship, caste continues, your lordship, irrespective of neither somebody can acquire a caste, nor somebody can renounce a caste. My children may not get the protection of being a tribal if there are evidences that they were brought up in my husband's family.
That issue has not been framed, but the point has been settled by the Supreme Court in 3 judgments. One arising from Kerala, I think so. Other arising from Chennai.
The children will
No, not the children. Conversion does not permit continuation of the status of scheduled career, as I remember, but that is not the issue before us. But अभी 25 में भी जजमेंट झारखंड में नहीं हुआ.
हम लोग
सुप्रीम कोर्ट
को मालूम था सुप्रीम कोर्ट का 25 वाला जजमेंट नहीं देखा है. तो पुराना जो जजमेंट था उसमें था कि मदर विल कंटिन्यू टू गेट द प्रोटेक्शन, द चिल्ड्रन कैन नॉट क्लेम बेनिफिट unless they need evidence.
But anyways, that is nobody's argument, so let's forget that. That's it. So your contention is that she did not seek a declaration.
He did
not seek a declaration. We continue it tomorrow.
But you can it be declared?
No.
Only for the reason tomorrow is a special thing for ED. Wednesday को हम पहले भी बोले.
Second half में होता है कि first half में होता है?
कल after the above display and second half the honorable chief justice was hearing will be matter fixed. इसलिए परसों कर दिया जाए as a first case and the first case only admitted.
The matter has remained inconclusive. Where is your synopsis of argument? वो भी क्या मतलब बाया नहीं सो
नहीं फाइनल है अभी फाइल कर रहे हैं
ये तो आप फाइल किए हैं अपीलांट और आप
I was not tempted.
if you do not submit it, you do not submit it at your risk.
No, I prepared it.
कोई ना कोई चीज छूट जाएगा.
हाँ.
फिर क्या जजमेंट होगा?
नहीं.
ये रिव्यूज एसएलपी करते रहिएगा.
नहीं एकदम पॉइंट वाइज.
The argument has remained inconclusive. Post this case for further hearing. Yeah, at the request of the counsel for the respondent. For further argument of the respondent. Supplementary is बेल हो जाएगा उसके बाद सुनिए.
हाँ जी.
ये कुछ है डॉक्यूमेंट्स इसको